Quite full and there is all this media going on, but I'm going to remind you and request that this is still a court of law. I'm expecting extreme calmness, order, as the court procession goes on, and silence. Those that have their phones on, kindly have them in silent mode or switched off. I do not expect any distractions under this matter.
Rwanda and Bayan Fulinawe. Bayan Fulinawe and Pura.
Hello, microphone 1 2. Hello, audio testing. Hello, microphone. Hello, audio. Hello, audio. Audio 1 2. Hello. Hello, microphone. Hello, audio testing 1 2. Hello. Hello, hello, hello.
We have an application to make before any other step is taken. And this now takes precedence over the other one. I'll say, Your Worship, we have an application to make before any further step is taken in these proceedings, which, in our opinion, we consider to be fundamental and takes precedence over any other matter if we are permitted in worship to proceed with the same before they can even talk of producing any other details. So glad to be Your Worship. Your Worship, it's an application brought under Section 5 of the Human Rights Enforcement Act, Cap 12. And it's about enforcement of rights and freedoms by magistrates' courts. First, to address your jurisdiction and then the procedure. On the question of jurisdiction, Your Worship, it is subsection 1 of section 5, which provides that a magistrate's court, subsection 1 of section 5, which provides that a magistrate's court shall hear and determine an application relating to the enforcement and violation of human rights and freedoms guaranteed in Chapter 4 of the Constitution in any of the circumstances not referred to in section 4, subsection 1, because those ones are for the High Court, Your Worship. That is the jurisdiction vested in this honorable court. And the procedure, Your Worship, is also provided for, or rather stipulated under subsection 2, that the application under subsection 1 may be made in any language, orally, in any language, orally, or in writing, or in any other form as may be prescribed by regulations. So there is a wide latitude on the procedure, Your Worship, and we are seeking to make it orally before you. And finally, on the procedure, subsection 2 of section 7, subsection 2 of section 7 provides that where a human rights matter arises in any proceedings before a magistrate's court, the court shall immediately stay the proceedings in the main matter and first determine the human rights issues raised. Where a human rights matter arises in any proceedings before a magistrate's court, the court shall immediately stay the proceedings in the main matter and first determine the human rights issue raised. That particular provision, Your Worship, is couched in mandatory terms, and we seek your indulgence, Your Worship, that we first deal with the human rights issue in accordance with the law. And the human rights issues we are raising, Your Worship, are as follows. Number 1, Your Worship, deprivation of liberty of A1 Dr. Besigye without any lawful justification, contrary to the provisions of Article 23 of the Constitution. Article 23, Subarticle 1, provides that no person shall be deprived of personal liberty except in any of the following cases. A, in execution of a sentence or order of court, and so on and so forth. So in this particular case, Your Worship, facts speak for themselves that Dr. Besigye is in the custody of the prisons authorities who are guarding him here. Yet this honorable court granted him bail. It's on record. Court granted him bail. To Your Worship, he has no any pending charges whatsoever under any court of law in Uganda. It's not there. For the record, Your Worship, previously there were charges that had been preferred against him before the defunct General Court Martial in Machindya, which charges were terminated, rather the charges and the proceedings were terminated by the Supreme Court in its landmark decision, Your Worship, of 31st January, which I'm sure court has taken judicial notice of. And the state is aware of this. Your Worship, it's straight law that one cannot be on remand without a valid remand warrant, without a court order. It's straight law. No person can be on remand without a valid court order or remand warrant, we challenge the state and the prisons authorities to produce any valid remand warrant under which they are keeping the applicant, who is their chosen person, Dr. Besigye, in custody in Luzira. There is none. And therefore, court cannot countenance that egregious abuse of the Constitution, particularly Article 23. Your Worship, which is also the other right, which is also granted under the Constitution, Article 23, Sub-Article 3, which provides that a person arrested, restricted, or detained shall be informed immediately in a language that the person understands of the reasons for the arrest, restriction, or detention, and of his or her right to a lawyer, and so on and so forth. This provision is quite instructive, that a person whose liberty is curtailed, who is restricted, who is detained, shall be informed of the reason as to why he is in custody or is in detention. Your Worship, Dr. Besigye up to now is not aware of any justifiable reason under the laws of this country as to why his liberty is being curtailed. That is about 23, Sub-Article 3. The other right which has also been violated is enshrined in Sub-Article 5 or Clause 5 of the same provision, Article 23. That where a person is restricted or detained, the next of kin of that person shall, at the request of that person, be informed as soon as practicable of the restriction or detention. 2, the next of kin, lawyer and personal doctor of that person shall be allowed reasonable access to that person. The full import of this provision is that a person restrained or detained has a right to access his personal doctor. Your Worship, your applicant here, they are chosen the person, Dr. Besigye, is sick. Last time he appeared, last time this court sat on Tuesday, he even wrote a cheat that he is indisposed. He could not make it. My colleagues and I visited him on Wednesday in Ruzira, and indeed confirmed that he is sick. And the prisons authorities can also confirm that he is sick. But to date, he has not been at all permitted to have his personal physician examine him or offer him any medical support needed. This is a gross violation of Article 23, Sub-Article 5, and also the next of kin. The next of kin should know the reason why their loved ones are restricted, or rather restrained or detained. Your Worship, the spouse of the applicant, that is the Honorable Winnie Byanyima, who is in the country, has not been furnished any reason as to why her husband is in Ruzira. On a light note, Your Worship, and to substantiate this matter, today is a Valentine's Day. It's a day for loved ones to share pleasantries. It may sound light, but it's a very serious one. Dr. Besigye should also be with his loved ones today. Not only his wife, but all his relatives. He's a family man. It's a day of families to reunite, to show affection to one another.
Monday, his sister was denied access.
And on Monday this week,
Stella.
this week, his sister, Stella, who had gone to take supplies to him, food items, was denied access to him. Finally, on the rights which have been violated, under Article 24, Article 24, Your Worship, provides for the right to respect for human dignity and protection from inhuman treatment. Respect for human dignity and protection from inhuman treatment. The kind of cruel and inhuman treatment Dr. Besigye is subjected to is horrendous, is reprehensible, is preposterous. Your Worship, to be in custody of the prison's authorities without a valid remand warrant, without a court order, is such an egregious abuse of one's right, which court cannot sanction or approve. We may be even on record, Your Worship, even writing a small cheat to his loved ones or the lawyers, whatever, is a tug of war. Just a small cheat. Even when we visit him, the environment is not conducive at all for a lawyer-client interaction or interface. Literally, the prison's authorities participate in the conversation, the discussion. There is no confidentiality. You are seated, you are given a room there, they bring the prison's authorities, they are there, listening to you as you are laying strategies on how to defend your client. That is inhuman. It's cruel. It's a violation of the Constitution. What are the available remedies, Your Worship? In subsection 2 of section 7, we reiterate that particular prayer. Subsection 2 of section 7. Yes. The first remedy is to stay the proceedings and dispose of the human rights issues. That's what subsection 2 provides, that this court stays the proceedings. It's our prayer that you stay the proceedings and first dispose of the human rights issues of violations that we have raised here. In subsection 9, and rather in section 9, orders that may be made by court in human rights cases. Subsection 1 of section 9, where the competent court determines that a fundamental right of freedom has been violated, unlawfully denied, or should be enforced, the competent court shall issue orders it considers appropriate, including an order for compensation. We may not ask for compensation, Your Worship. Your Worship, we pray that you be pleased to invoke the powers of this honorable court under subsection 1 of section 9 to issue appropriate orders, because it gives you the discretionary powers here, Your Worship, that the court may grant orders it considers appropriate. And in our opinion, the most appropriate order this honorable court can give is immediate release of Dr. Besigye from unlawful custody. Immediate release. That is the most appropriate now. The other order, Your Worship, in subsection 2, paragraph C, subsection 2 of section 9, orders which shall include measures aimed at cessation of the continuing violation of human rights and freedoms. To order immediate cessation of violations. And here, Your Worship, if you may add on another prayer. Okay. It's under that provision that, Your Worship, that this court is clothed with the powers to order for the release, immediate cessation. You are clothed with jurisdiction to order for the immediate release of Dr. Besigye. The other prayer, Your Worship, we are making for regards to violations under Article 22, the last one now, Your Worship, under Article 22, protection of right to life. No person shall be deprived of life intentionally, except in execution of a sentence passed in a fair trial by a court of competent jurisdiction in respect of criminal proceedings under the laws of Uganda. They are threats to the life of the accused person, Your Worship. Threats to life. The circumstances under which he is being detained pose a serious threat to his life. The horrible treatment he is subjected to But even a statement issued by the army, the CDF himself is on record issuing threats that Dr. Besigye shall only leave Luzira in a coffin. He's on record saying that. That is General Muhoozi Kainerugaba. That Besigye shall only leave Luzira in a coffin. That's a very serious one, Your Worship. So this court is enjoined to protect the life of the accused and all his other rights. Of course, the other threats that will be subjected to firing squad in June and whatnot, but we wanted to single out the one relating to his imprisonment now, that will only leave Luzira in a coffin. So we pray that, Your Worship,
criminal sanctions against the DPP and the prisons.
and the other prayer, the last one we are making, the prayer, Your Worship, is in subsection 2 of section 9. That is paragraph 5 and 6. That court can issue criminal and other judicial or administrative sanctions against the persons liable for the violations criminal and other judicial or administrative sanctions against the persons liable for the violations. To start with, these ones. These ones, Your Worship.
And the battalion behind you.
All these security officers in charge of his custody, starting with the Commissioner of Prisons, should be sanctioned. Mr. Byabashaija Johnson should be sanctioned. Your Worship, the Director of Public Prosecution is equally liable in this, together with the Attorney General. They are equally liable in this. They should be subjected to criminal sanctions for violating Dr. Kizza Besigye's rights. We do so pray.
Non-repetition.
We do so pray, Your Worship. Thank you. Your Worship, if I may be permitted, with the leave, Your Worship, I'd left out one prayer in 6 because I had highlighted it, Your Worship, to guarantee non-repetition, that court, amongst the orders that can be issued, guarantees of non-repetitions. So court is again enjoined to make some safety measures and provide mechanisms to ensure that there is no repetition of violations. In other words, they should not be allowed today to go back with the Dr. Kizza Besigye to Luzira. They shouldn't be allowed by this honorable court to take him back to Luzira, because that will be, again, violation of these provisions. We do so pray, Your Worship.
Here are the sections referred to by my land colleague refers to where in any proceedings. That means the violations mentioned here. The violations should arise from the proceedings before a given court. The violations suggested by my land colleague should have arisen from these proceedings, which is not the fact. You know, an accused person cannot be in court, faces other violations, then he uses them to stay proceedings in a totally different trial. You know, that is a fallacy. So, Your Honor, this Honorable Court cannot stay these proceedings or make any orders. Your Honor, unless my land colleague had brought a separate application, because the remand of A1, his incarceration in Olulabye, has no connection with this case in court. Therefore, applications cannot arise from this case and prayers made for his immediate release, when in this matter he's already on bail. Your Honor, it is clear that from the proceedings before this court, there is no human rights violation against A1. Not at all. He is on bail. Your Honor, that should be very clear. Therefore, the submissions by my land colleague that this court should issue orders for his release are untenable. Have no backing. And you know, all case law under the Human Rights Enforcement Act, where parties have been successful, the violations have been arising from the given cases. Either they allege torture from police, but that torture should be as a consequence of their incarceration. It cannot be done at a different case where you're on bail and you meet a person on the road, they stone you, then you come and say your rights have been violated. So this case should stay. It's unheard of, Your Honor. So therefore, Your Honor, my land colleague should have filed an application, a totally different application, for his incarceration has no bearing on this case. Two, Your Honor, I will still move on to the fact that his incarceration is unlawful and he was released from jail by the now defunct court martial. Your Honor, this is not true. The judgment of the Supreme Court was very clear that the trials would be transferred. The judgment didn't state that the trials are stopped and people should be released. That is a fallacy. There is no such judgment. So, Your Honor, he is in prison legally until the case files are transferred to a civil court. And Your Honor, the Supreme Court gave 14 days. We are still in the 14 days. So, Your Honor, even if court agrees with my land colleague that, okay, the violations that, if any, that are being occurred to him arise from this case, and this court has jurisdiction under these violations, there is not any such violation. So, Your Honor, there is no ruling or judgment by any court that trials of civilians in the general court martial, that people have been tried in the general court martial should be released from prison. and that their incarceration is unlawful. It is not there. So you know the questions of you should either seek bail from a court with competent jurisdiction or seek other orders, but not through this court, using this case. I would submit that the reason for his incarceration are not the concern of this honorable court. This court should not even look into the issue of his incarceration in Nigeria. He is on bail. The issue should be handled by those who incarcerate, who remanded him, or if they make any application, which is independent of this case. They cannot mix his incarceration and this case. They are totally different matters. So I don't want even, due to that, I don't want even to go into whether they are violations, whether his rights are being violated. You're not legal. And there is no ruling that is illegally in prison. You cannot be in prison and celebrate Valentine, as my land colleague wants. It won't happen. There are inconveniences of life. Or have total. So, I would sum up that, this court has no jurisdiction to make orders arising out of its incarceration. That is in as far as these orders arise from this criminal matter. They should have made a separate application to this honorable court. For his incarceration has no bearing on the case before this court. 2, if I am wrong and indeed this court has the jurisdiction, he is not illegally in custody. He is in a lawful custody. And the Supreme Court judgment is clear, he is in a lawful custody. So, I would pray that the prayers by my land colleague that Attorney General DPP be reprimanded and the prison. No, what they are doing is lawful. So there is no illegality that has been made. So I would pray that this honorable court dismisses the application and allows us, we had made the first and allows us, this honorable court should allow us to present our last witness today, and we have all these times been chastised by my land colleagues for not presenting witnesses. When we present a witness now, my land colleague doesn't even want to hear about the witness at all. So we pray.
So just give me a minute. Getting an IT malfunction here.
Your Worship, very briefly in rejoinder, I think there are 2 points that the state is making, and I'll start with the last one. That A1 is in lawful custody. Essentially, what the state is saying is that A1 should not be complaining because he is lawfully incarcerated. Your Honor, the Supreme Court judgment did not say that A1 and other persons in his category should remain in custody. So we are at a point where the warrant that remanded him expired. About 2 weeks ago.
3rd February.
The court which issued that warrant was told not to sit again. And this is the first court that he has appeared in for the period for which he has been in illegal detention. Your Worship, my learned friend Mr. Lukwago asked the state to produce the document under which he is incarcerated, or even the prison's officials. The state skirted around that issue because in reality there is none. So he might be in the category of people who used to be called lodgers many years ago. They are in the prison system under no authority of any office, any court order. Your Worship, the state has not even addressed any of the instances that my learned friend cited in Article 23. He just ignored them as if they don't exist. So we submit that the unlawfulness of the custody for A1 is clear. And we invite the court to act in the manner provided in Section 9 to grant A1 the necessary remedies. On the question of jurisdiction, it is our submission that the court has the necessary jurisdiction. It is in black and white in the text that my learned friend read, Section 7, subsection 2. And 5, 1. And it is not an error that this jurisdiction was given to the courts. The provisions do not speak of any proceedings and then say any violation in those proceedings. And so our interpretation, Your Honor, is that both Section 5 and Section 7 apply to this situation. This first court that the accused has appeared in is the one where he is raising the human rights violations that he has been facing for the last 2 weeks, at least. We therefore, Your Worship, reiterate our prayer that the court exercises the jurisdiction it has to stay these proceedings, order cessation of the continued unlawful detention of A1, to order the authorities to seize any repetition of that unlawful detention, and the other prayers that my land friend made. Your Worship, it would be a travesty for the court, being aware of the violations, to tell those violating to continue, or to tell the one who is complaining that I can't hear you, I have no remedy for you. You go back and continue to suffer. Your Worship, that's what would happen if the court were to find otherwise. So we very humbly pray that the court grants the remedies we are seeking. Certainly, again on a light moment, it would be an amazing gift on a day like today for that type of order to be made. We so pray, Your Worship.
Some brief additional submissions, Your Worship, on the question of jurisdiction. Strictly on the question of jurisdiction. Your Worship, the nexus between this application for enforcement of rights and the trial before you. I think he dwelt so much on that point, to drive a point that actually these are different matters altogether, not at all related. Your Worship, in addition to the submissions made by my land friend Kikolebwa here, it's our strong position that that would be a parochial interpretation of Section 5 of the Human Rights Enforcement Act. It would be a very narrow interpretation. Emphasis, Your Worship, should be put on the spirit of that provision, where Parliament, in their wisdom, said in subsection 2 of Section 5, the application may be made in any language, orally, in writing, or in any other form, meaning that actually person can even walk into your chambers even without any pending matter. Any person whose rights have been violated can simply walk into your chambers if by any chance they find you there and say, Your Worship, my rights have been violated. Orally there, in a language they understand. That's how informal the proceedings relating to enforcement of rights are. So we needed not even have this matter pending before you. Even if there was none, we would still walk into your chambers under that particular provision, orally. That is one leg of the submission, that we did not even to relate the matter to the proceedings before you. But on the flip side, Your Worship, even if we are by any stretch of imagination to go by their argument that you needed to correlate the proceedings before you and these matters, still, Your Worship, he misdirected himself on this. Your Worship, let's go back to the genesis of today's proceedings. On Tuesday, we objected to this Honorable Court issuing a production warrant against Dr. Kizabesi and said, you granted him bail. They applied for a production warrant and said, this Honorable Court cannot issue a production warrant to a person who is on bail. And that's what gave rise to the proceedings of today. Because why would somebody admitted to bail, who is supposed to come from their home, be subjected to a production warrant? So they are here to explain why a production warrant should issue against the prisons authorities to bring back somebody who is on bail. That is the nexus. And two, Your Worship, this Honorable Court has got an obligation to interrogate issues relating to the freedoms and rights of a person they granted bail. There are conditions that were attached to bail, that he should comply to the orders and appears and when directed by court. But now he cannot, unless brought by the prisons authorities. He cannot of his own comply to the conditions of bail of this Honorable Court. If you directed that he should come back on Monday, can he bring himself? Because those are the conditions of bail. Are they going to be varied? That now he will now be brought by prisons authorities, not himself coming. How about the sureties now? The sureties who were bonded by this Honorable Court to ensure that as and when this Honorable Court wants him, they should cause his appearance. Do they have now capacity to go and break the prison and bring him? So that means the orders given by this Honorable Court are rendered nugatory. The orders relating to bail, they are rendered nugatory. And this Honorable Court cannot sit and watch its orders being violated with impunity. They become illusory. That you admit somebody to bail, and then under serious circumstances is restrained, and the court does not interrogate that matter. So this court has that jurisdiction, actually the mandate to interrogate into those issues. So that is the nexus we can draw between the two matters. But our strongest point is that we don't even need to go there. The mere fact that one has appeared before court and raised a return of violation of rights is enough. In our opinion, right now, Luzira has been turned into a safe house in as far as the liberties of Dr. Besigye are concerned. That is the lodging, and that notion has always been there, Your Worship. The people they call lodgers within prisons premises. He is a lodger in Luzira, which is now just being considered as a safe house for him, without any pending charges. Finally, the issue of 14 days of the enforcement. I don't know where my land friend is picking it up from. That the Supreme Court said that they are given 14 days within which to keep all these suspects in custody. That is reading too much into the judgment of the Supreme Court. I invite my land friend to read it, if he hadn't. We beg to submit, Your Worship.
The submissions of both the defense and prosecution have been heard. The court takes cognizance of the fact that human rights violations, once brought to the attention of the court, must be dealt with expeditiously. However, several provisions of the law, authorities, and scenarios have been placed before the court by both the defense and prosecution. In reply as well as rejoinder, the court owes it to itself a duty to carefully internalize and draw the provisions of the law and violations cited into perspective before a decision on the prayers can be made by both defense and prosecution to be arrived to. The matter is going to be given an adjournment for a ruling on a date. Council, I have the 28th of February, if it's available to you.
Why not Monday, Your Worship? Today is 14.
Can you work with the 20th of February? Next week is the 20th. It's within next week, 20th of February. Thursday, the 20th of February, if it's available to you.
Anything next week is available to us.
This one is next week, I think. 20th February is next week, Thursday. Just to allow me time to also internalize all the submissions you've bombarded me with. The prosecution has made submissions. I also avail myself a chance to look at the authorities and the provisions of the law. Then we can reconvene for a decision. And so there might be no point in me giving you a date when the court will not be able to entertain a sitting. But Thursday is very open and Friday the 21st. All within next week. Is it available to you?
Anything given to us for this matter, Your Worship, the soonest we have it disposed of, because we are talking about rights, Your Worship.
So the matter will be adjourned to Thursday, the 20th of February, for ruling. Accused is on bail in this particular matter, and his bail shall extend until then. However, the court is not blind to what is happening and that is being produced by prison authorities. So by this adjournment, I'm also ordering prison. If on such a date is still in your custody, produce him in court.
not treat this as a remand order, Your Worship.
I do not think they need a remand warrant. They are here with the gentleman. Will you need that? And they've had the date, the 20th of February.
Because he's on bail. But they may misconstrue.
Prisons never disobeys orders of court, especially when they are present. It has never happened, at least not in all my years of service. So I don't imagine that they will not produce him unless doctor himself opts not to appear.
No, our word was for them to misconstrue this as an order of remand.
No. I have clearly stated in this particular matter, Dr. Besigye is on bail. His bail is extended till that date. However, I am not blind that he's incarcerated somewhere in a different matter. So I'm ordering the people who are here that in the event nothing has changed and is still with them, they produce him on that date. It is as simple as that at 10 a.m. With that said, Council, I have other matters ongoing. Members of the 4th Estate, if you could vacate my court so we can proceed with other hearings.